Hello and welcome to this Cornerstone webinar. We're going to move to the first slide, and although I think people are still joining, we're going to get going because it's a little after 2. Over the next 45 minutes or so, Emma Dring and I will take you through some of the most challenging and interesting issues in planning law. We'll try to do them justice and bring you right up to date. Emma will begin and she'll speak for about 20 minutes on the tall buildings and recent consultation on harm and on optimum viable use. I'll then take over and deal with the other matters on this slide listed there. Then we'll move to questions. I hope we'll have time to deal with some questions. Thank you for those that have already been submitted online. Many of these we've managed to incorporate into our slides, but do make use, if you feel moved to do so, of the Q&A button at the bottom of your screen, and we'll deal with as many of them as we can within the webinar, or perhaps in writing afterwards as necessary. There will also later be shared a feedback form. Do give us feedback. Do tell us how you think we're doing and how useful it is and what might be improved. We do pay attention to that. And in due course, a copy of the slides and indeed a recording of the webinar will be available on our website. So you can catch up and look again if you so wish. Now to the subject matter of the webinar, and over to you, Emma. Thank you.
Thanks very much, Harriet. So my first of 3 topics is about tall buildings and heritage impact. And really examples of why this is an important issue are all around us. We've got some examples for you on this slide. Across the top, you can see firstly the walkie-talkie building behind Tower Bridge. That was the winner of the 2015 Carbuncle Cup. And I just have to read you the description. A gratuitous glass gargoyle graffitied onto the skyline of London. That's been criticised, and I think a lot of people think in retrospect it was not a wise decision, not least because of heritage impact. Then in the middle you've got Chiswick Curve, recently rejected by the Secretary of State, and I'll talk more about that shortly. And then on the right hand side you can see a development called Manhattan Loft Gardens in Stratford, seen during construction from Richmond Park, which was a protected, or is still a protected, view of St Paul's Cathedral. And then along the bottom, 3 different iterations of proposals for St Michael's development in Manchester. That got a lot of headlines. A couple of years ago, it's the one that's being promoted by Gary Neville and Ryan Giggs, that's seen there behind the Grade 1 listed Albert Memorial and the Grade 1 Manchester Town Hall. And I think the final the far right is the current proposal for that. So the relationship between heritage assets and tall buildings is increasingly important, and there are a number of reasons for that. Firstly, the sheer number of tall buildings which are now being built, and that's not just in London. Secondly, modern building techniques now mean that buildings can be built to heights that were simply unthinkable not that long ago. And with that greater visibility comes the greater potential for impact. Thirdly, there's something of a trend, I think, for more innovative designs, which by their nature are very modern and designed to stand out. And so there can be a particularly striking contrast between that modernity and historic buildings. There's also the fact that planning policies favour greater density in certain areas, so that often leads to higher buildings. And as this slide is an example, there have been several high-profile examples where things perhaps haven't gone well in terms of heritage impact. So I'm just going to cover 2 recent developments on this area. Firstly, a consultation on the updated Historic England Advice Note, and then secondly, I'll touch on the Chiswick Curve case. So Historic England, they already had an advice note on tall buildings dating from 2015. There is currently open a consultation on a revised version, which actually closes today. So if you've got any comments to make on it, I would hurry up about it. In terms of what's going to change, there are some minor amendments just to take into account more up-to-date policy. Of particular interest, I think, a greater emphasis on design and good design. which reflects trends, I think, in national policy more generally. In the last year, we've had the report of the Building Better, Building Beautiful Commission, and also the Planning for the Future policy paper, which made various commitments to kind of improving the role of design in national policy. And given the prominence and visibility of these tall buildings, it's obvious that design is going to be really important. So more emphasis on that. And then some more useful material about how to define tall buildings, which builds on the previous version of the advice. I think the main point really is that the number of stories or the height in metres isn't the only factor when one is considering whether a building should be regarded as tall. Surrounding building heights, the level of the land, and even the location of the viewer can all make a difference on perception. So it's important to pay attention to how policies define what is tall. And then moving on, a more of an emphasis in the updated advice note on the importance of plan-led development. So there's a lot more detailed guidance in there than the previous version on evidence base, content of policies, and the protection of important views. And I think a major criticism, certainly of the increase in tall buildings in London over the last decade or so, has been that it's been insufficiently plan-led. And I think the London plan has been considerably strengthened on that issue in recent years. But it's absolutely not just a London issue. In doing the research for this talk, I noted that in Manchester, as of January this year, there were 37 completed buildings of 20 stories or above, with 45 permitted or under construction, and another 60 in pre-planning or awaiting determination. And these proposals are increasingly coming forward in other cities, Leeds, Southampton, Birmingham, to name a few, and indeed in areas outside traditional city centres, and the Chiswick curve is an example of that. So this all indicates how incredibly important it is for development plan policies to address this type of development specifically. Otherwise, you have a risk of a policy vacuum. And Historic England is recommending locational policies, so areas where tall buildings might be appropriate or inappropriate in principle. And obviously having a proper evidence base to underpin that is really important. Or in the absence of that, criteria-based policies to determine when a speculative proposal, I suppose, may or may not be appropriate. So we'll have to see what the final version of that advice note looks like, but those are some of the major developments in it. And I'm going to move on then to Chiswick curve, because this is a practical illustration of some of the points that I've just touched on arising from the Historic England advice note. It was a proposed 32 and 25 storey building in the London Borough of Hounslow at the junction of the M4 and the North and South Circular, which was refused in 2017. It was a recovered appeal by the Secretary of State, and then there's recently been a High Court challenge to the Secretary of State's decision. That judgment was handed down on the 10th of March this year. And in terms of policies for the Chiswick curve, it's just interesting to note, following on from what I just said, that in the existing plans, there was nothing site-specific about this particular location. There were general criteria-based policies, both in the London plan and in Hounslow's local plan. In fact, that was a very detailed, I think there were 12 criteria in that policy. But the emerging Hounslow plan actually identified this site as being appropriate for a tall building of exemplary design. So it was an area considered to be appropriate in a location-based policy. The inspector essentially found that the benefits of this building outweighed the less than substantial harm to heritage assets, and there were a lot of heritage assets that were involved in this case. For conservation areas, the World Heritage Site of Kew Gardens. And essentially when you read the decision, it's pretty clear the inspector was very taken by the design of this building. He thought it was of the highest architectural quality, quite a brilliant response. He talked about it being a very exciting proposal. So in his view, that compared favourably to an alternative scheme, the Citadel, which already had planning permission, but hadn't been built out and apparently wasn't considered viable. The inspector thought it might be able to be made more viable, and anyway it might come forward even though it wasn't viable, so it couldn't be ruled out. But he said about the Citadel that it fails to attain the level of architectural sophistication one ought to expect of a tall building. It would be extremely unfortunate if it was progressed. So clearly design was critical in his view. Secretary of State disagreed, essentially said that this would be dominating the local area due to its scale and massing, gave no weight to design as a benefit in the balance, said the economic benefits would arise from an alternative proposal, and refused permission. In the High Court, the claimant was essentially arguing that the Citadel, the alternative, would be worse or at least as bad in terms of heritage impact, but it wouldn't have the design benefits. So essentially saying the Secretary of State ignored that, and he might have granted permission if he'd have taken it into account. That challenge didn't succeed. The judge didn't agree that the Secretary of State, sorry, the inspector's assessment was quite as stark as had been portrayed. And it was clear the Secretary of State was aware that the alternative proposal would also cause heritage harm. And then the court looked at reasons and said they were sufficient. And importantly, there wasn't a requirement to balance, essentially to conduct a full paragraph 196 balance of the benefits of the Citadel against heritage harm. That wasn't a principal controversial issue in the case. So what does that case tell us? I think, as I indicated earlier, design of tall buildings can really be a make or break factor. But I think what the disagreement between the inspector and the Secretary of State on this shows that it can be a very subjective point. But it really, I suppose, underpins why it's a point that's being beefed up in the Historic England guidance. As always, it's difficult to succeed on a reasons challenge. And interestingly, where heritage impact is in play, it is sometimes necessary to consider alternative schemes, but that doesn't mean that they need to be assessed to the same degree as the proposal that's actually being determined, whether it's an application or an appeal. At the end of the day, that is not the proposal that's before the decision maker. So that's what I want to say on tall buildings, but that point on alternatives brings me neatly on to the issue of optimum viable use, which I think is something that certainly from the pre-submitted questions has sparked a lot of interest and comment. And it's something that hasn't really featured a huge amount in the case law, certainly until recently. I've already touched on Chiswick Curve and how alternatives were considered in that case. And there's a general duty where heritage impacts are in play, that it might be necessary to consider potential alternative schemes. That is a departure from the general rule that normally alternative ways of developing land aren't relevant, and decision maker would normally only consider what was before them and not looking at a range of options. But it was said as in Ford Field that the statutory duty implies the need for a suitably rigorous assessment of potential alternatives. So that might be looking at alternative sites for development or alternative uses of the same site. And that just generally applies regardless of the nature of the impact. Optimum viable use is also requires consideration of alternatives, but it's more specific than that. I've given you an extract, paragraph 196 of the MPPF there on the slide. And it shows you that optimum viable use is something to be weighed against less than substantial harm. So it's viewed as a type of benefit. It requires, it's about the optimum use of the heritage asset itself is the point. So it's really only relevant where there would be direct impacts, so alterations to a listed building. Then you'd need to consider what the optimum viable use of the building was. It's not really relevant where it's a development that would cause harm to a setting, like the Chiswick Curve case, because you're not looking at the use of the asset itself there. And it's interesting to note actually that in the 2018 consultation on changes to the MPPF, the government actually proposed deleting the reference to optimum viable use altogether, but it ended up being retained with a commitment to setting out some clearer guidance on when it should be taken into account. And I'm going to call it OVU from now on because it's such a mouthful. given you this slide with the bit more definition of what the optimum viable use OVU is. Essentially, it's the use that's least likely to cause the least harm to significance. 3 points to note: only alternatives which are economically viable need to be taken into account. Secondly, you've got to look at future prospects. The PPG goes on to say that a series of failed ventures could result in a number of unnecessary harmful changes. So you've got to look at long-term sustainability. And then thirdly, the OVU may not be the most profitable use. So it does contemplate refusing permission on the basis that the developer could pursue a less profitable scheme, but one which would cause less harm to heritage. How does it feature in decision making? I've already said it's a type of benefit. Interestingly, in the Gibson case, which was about Arthur Conan Doyle's residence undershore, the court said that not delivering the OVU would be a compelling basis for refusing permission. So that's interesting. It's essentially equating not delivering the OVU with a type of harm as well. So that's how it may feature. When is it appropriate to take it into account? The PPG gives you some guidance on this, which I've essentially summarised on this slide. I think we had a question from Neil Robertson saying that the issue of OVU is particularly coming up in connection with proposals to demolish buildings in conservation areas to build flats. I think the third point on this side is relevant to that. OVU isn't really something that features or is a relevant factor when you're looking at conservation areas or World Heritage sites, because they're composite assets. It's a designated area, so it doesn't have a single use as such. Obviously, it might apply if the building in question is listed, but if we're talking about demolition, then that's obviously a case of substantial harm or total loss. So you're moving beyond optimum viable use there to looking at whether no viable use can be found. How much, I think this is a really interesting point, how much detail is needed about possible alternative schemes? That's been covered in 3 cases in the last few years. On this side, Fulham Town Hall, the first case where there were proposals for a retail arcade in the ground floor and a cafe and residential accommodation in the upper floors. This was a case where the council actually, on the appeal, put forward what was described as a carefully developed illustrative scheme for an alternative hotel conversion. That was considered by the inspector to be less harmful in heritage terms, but it wasn't viable. The appeal scheme was viable, but caused a lot of harm to heritage. And interestingly, in this case, the inspector considered that the OVU was actually an office or storage use, which was the basis on which a viability appraisal had been carried out. So there was it wasn't a rival proposal or any kind of existing use or a permission. There wasn't a detailed scheme. It was just a notional use. However, that wasn't determinative in that case anyway, because he said even if the appeal scheme was the OVU, the benefits still wouldn't outweigh the harm. So that was the first of the 3 cases. The second is this JHF Green case, which was about conversion of a house to a hotel. And it was alleged in the High Court challenge that there'd been a failure to consider whether the single residential use was should be OVU. And in that case, the judge said, well, if you're going, alternative proposals that might be candidates have to be demonstrably substantial rather than speculative. And in his view, he said it would have been open, in fact, to the local authority to discount any alternative use altogether because it was purely anecdotal and speculative. So there's certainly a limit in terms of how much information you would need before something could be a possible candidate for the optimum viable use. And then the third case was about Bramshill House and Gardens, a Grade 1 Jacobean mansion and a Grade 1 registered park and garden, and with a disclaimer that I was actually involved in the public inquiry in that case. Oh, I've gone the wrong way. There we go. And I think Lisa Foster asked a question about, she said she'd seen a case where the inspector took account of a less damaging scheme in deciding to dismiss an appeal, and that was upheld by the High Court. I think this could be the case that you were thinking of, Lisa. it was a proposal for, or one of the many proposals was for 235 houses within the registered park and garden, and that was going to help to restore, that it was going to deliver by funding the restoration of the park and garden and the wider setting of the mansion. And it was said that that was the minimum amount of development that could be provided for viability reasons. And the inspector essentially said there was an absence of evidence, so nothing had been put forward to show that an alternative approach could not be taken. There was no compelling evidence that this scheme was the OVU. So that a lot of aspects of that decision were challenged, but that in particular. And the High Court essentially upheld that and said, the quote there, basically, you're not only bound to have regard to alternatives where there's some detailed alternative scheme that's been put forward or even an outline scheme. And it was implicit in the inspector's conclusions on design that there could be other ways of building out that housing development which could be less harmful. Obviously that was not an alternative proposed use, but just an alternative way of delivering the same use. So that might make it easier, I suppose, to look at alternatives. But I think taking those three cases together, we can conclude you don't necessarily need to see a fully worked up alternative proposal or even an outline proposal to be a candidate for the optimum viable use, but it has to be something that's realistic and isn't merely anecdotal. And really, I think it's ultimately a question of planning judgment whether an alternative might be the optimum viable use or not. What does viability mean in this context, optimum viable use? A really technical subject which I cannot at all pretend to be an expert on. I've set out the basics of the standard approach at the top of the slide, but it was another argument that was made in the Fulham Town Hall case. Basically, the council was saying you shouldn't treat viability in the definition of optimum viable use just as the normal approach to viability. A use could be the optimum viable use provided there was any positive land value, a sufficient return to release the land, and the use would be sustainable in the long term. So I suppose essentially they were saying it's a watered down or less difficult test to meet in the case of OVU. There wasn't any conclusion reached on the issue by the inspector in that case. Essentially the council's hotel use wasn't viable anyway on either basis. The other alternatives were viable on the standard approach, so it didn't really need to be gone into. But certainly the inspector was uneasy about there being two different meanings. So that remains an untested point, but I think it's hard to see much justification for giving viability some completely different meaning. I think there are still clear issues around what evidence you might need to see to determine viability, and it might be that it's the case that decision makers should be requesting information on this subject, given that policy requires this issue to be considered. So that's all I want to say on OVU. I have some slides on issues to do with harm. I'm mindful of the time and that Harriet needs to have time to complete her presentation. So what I'm going to do is to skip through these. Essentially, the purpose of these slides was to answer some of the pre-submitted questions that we had on some really interesting topics, whether there's a scale of less than substantial harm or not. Questions were asked by Samantha Allen, Susan Leeson and Caitlin Boddy on that subject. What happens if there's no public benefit at all? Again, Samantha Allen asked about that. And then Andrew Martin, Deborah Lewis and Francisca Callahan all asked questions about setting. And essentially the law on that hasn't really changed since Steer. So I'm going to skip through those slides. They will be available for those of you who are interested in reading them. I'm sorry we haven't had time to cover them, but I'm going to hand over to Harriet now so that she can deliver her presentation. Thank you very much.
Thank you so much, Emma. And yes, now to the subject of climate change and renewable energy, implications for the historic environment. And just to remind us what we're talking about, I have the three of the sorts of onshore renewable energy proposals that you might be familiar with addressing, if you work in this field, a solar farm, a wind farm, and an energy from waste facility. I'm going to start with a reminder of, so to speak, where we're at in terms of our climate change response and following the climate emergency declared last year. The Climate Change Committee's annual report of July 2019 might be summarized by the phrase, must do better. Only one of 25 policy actions that were recommended to the council, to the government, were delivered in 2018. And only 7 of 24 indicators were on track in 2018. And that was with relation to the 80% target for 2050. So for net zero in 2050, emissions reduction, advised the CCC, must be 50% more per annum than required for the former 2050 target. Interestingly, they have very recently, the committee that is, published a document called Reaching Net Zero in the UK. It's easily found on their website. And amongst the things they say are these: major infrastructure decisions need to be made in the near future and quickly implemented. So speed. And we need extensive electrification supported by a major expansion of renewable power generation. So volume and speed. I'm now going to look at the position of the planning system in delivering those sorts of requirements. And I start with a picture of Lyveden New Bield. We all know how often it happens and how difficult it is to solve in a principled way the clash between the need for renewable energy and its impact on the historic environment. This was the building at the heart of the now seminal case, Barnwell Manor. I'm going to consider what is the national planning policy context for delivering the growth in renewable energy generation we know is necessary, and does it ensure the historic environment receives what we might all recognize as the right degree of protection? Do we know what the right degree of protection is? Maybe there are as many different views as there are people in this webinar. I'm going to start, as I say, with planning policy, and I'm going to look at Wales first. Thank you, Emma. The Welsh planning policy on large-scale renewables is found in Planning Policy Wales. There's a section 5.9, and the now fairly ancient TAN 8 of 2005 supports it. That sits notably separately from Planning Policy Wales section 6.1 on the historic environment and the more recent TAN 24. There is relatively little overlap between those, or cross-referencing between those sections. What approach does Wales take? Well, it's very much a top-down approach to the identification of strategic search areas, but then within those, to adopt a plan-led approach for the delivery of growth. The balance between need and impact tends to be solved, as it does in England, by the decision maker. And so Welsh government decision making is an important aspect of analysis in this situation. There is very much a pattern in Wales, many examples where the benefits of onshore renewable energy are said to outweigh harm to the significance of more than one nationally important heritage asset. Often decisions are taken against the government's own advisor, Cadw. A few thoughts about this. These are essentially political decisions and are in that sense, in principle, justifiable. But it seems to me the policy framework should be more explicit about the priorities of government. Secondly, there's no guidance from Cadw on major renewable energy projects at all. Indeed, they have no independent statutory role to provide guidance. They're actually part of government in Wales, unlike historic England, set up by the National Heritage Act. So there is in Wales no independent advisory body like there is in like historic England, although the Historic Environment Wales Act, Section 38, makes provision for one. It's not yet in force. I'm going to contrast that approach, the pro-development approach of the Welsh Government and the background context with that in England. In England, we have the NPPF. Paragraphs 151 and 154 are not the only relevant policy paragraphs, but they are pretty key. And footnote 49 is notorious. Local community backing is needed for onshore wind. And again, as in Wales, the historic environment policies are largely separate and there's relatively little cross-referencing. The NPPF is supported by the PPG, which requires great care to be given to conserve heritage assets, as you would expect. And in relation specifically to onshore wind and solar, there is a warning that these have the potential for substantial harm caused by the development in the setting of heritage assets. NSIPs, EN 1 and 3, repeat general heritage policy and do note that from 2016 onshore wind has been removed from the NSIP regime. Since the NPPF policy was introduced with footnote 49, which requires effectively the support of local communities, only 2 single turbine appeals have been allowed, so far as I'm aware, from a review of Compass. Nothing at scale, and indeed these benefited from transitional arrangements, exempting them from showing the local plan had identified the area as suitable. What are the implications for delivery? Next slide, please, Emma. Thank you. Now, this has inevitably been an absolute whistle-stop tour of the policy, and I'm sorry if it's taken it too briefly, but you can see that reliance on onshore renewables, especially wind in England, to respond to the climate emergency may be unwise. In England, reliance on community support appears, this is my own view, naively optimistic. The development plan process is slow. I think that's a common view. And nowhere is there objective guidance on how to strike the balance between the public benefit of renewable energy and any residual harm caused to the significance of heritage assets. On top of that, delays in securing consent and the economic effect of the coronavirus have to increase the challenges. Next slide, please. Into this context is introduced the Historic England Consultation on an advice note headed Commercial Renewable Energy Development in the Historic Environment. As with the tall buildings, consultation ends today. So no doubt all of you have responded if you intend to do so. But it does not cover small-scale domestic projects. It's an overview only of historic environment issues. There are chapters on offshore wind, on solar, on biomass, and on energy from waste. But there is nothing on onshore wind. And indeed, the chapters themselves explore specific issues. They don't assist with the balance itself of harm and benefit. But arguably, that wouldn't be the role that wouldn't be an appropriate role for historic England in any event. So the heading of this slide, it adds little to the MPPF. Arguably it can't, because ultimately the striking of the balance is a political decision. It's for policy to grapple with it. And politicians are showing no appetite whatsoever for moving away from their current position, in which they have room for maneuver on a case-by-case basis. And indeed, these paragraphs from Historic England's draft note make that clear. This is a case-by-case decision. And whatever is said about weight, ultimately, it comes down to an individual decision of an individual Secretary of State on the specific circumstances of an individual case. Very difficult to give guidance for the generality. Does this draft note contain some useful tips? You may think so. You may also think they are simply standard practice, adding nothing to existing good practice advice. And on that, I leave that to your good sense to reach a view whether it's helpful to you. It does note the importance of visualizations and good quality visualizations, of the use of an appropriate focal length when providing visualizations, and on pre-application engagement, all of which contribute to the ability of applicants to enable their design to take account of heritage assets, and that obviously has to be a good thing. On that note, I'm going to move to my next subject, which I can deal with more briefly. There are three issues I'm going to take one by one that occurred to me were of particular interest to those trying to push ahead with work within the heritage sector, with planning work in particular within the heritage sector, and I'll deal with them one by one. The first is what happens on consultation and publicity. How are local planning authorities dealing with the requirements of consultation and publicity? Well, the second bullet on this slide provides the essence of the point I want to make. Since amendments to regulations in England were introduced just last week, or 2 weeks ago now, sorry, greater reliance on the use of a website to carry out consultation and publicity is permitted where it is not reasonably practicable to post a notice or publish in a local newspaper. This has led to amendments to the PPG, which are very helpful. Do look at them. They provide a useful guide on what might qualify and how to respond. Next slide, please. Issue 2, survey work and site visits. The looser lockdown that's been in place for the last 2 weeks does make these easier. But as before, I suggest the main questions are, can the information I need be obtained from my desk? If so, no need for a site visit, don't go. If it can't, you ask yourself, can the site visit be undertaken safely? If so, go. If not, obviously, don't go. But document that fact and keep it under review. I've noted the current end point of the current restrictions, which could change in either direction, of course, and would add that the government is expecting planning authorities and those exercising regulatory functions during this period to use their ingenuity and try to maintain a functioning planning system. And that brings me to the third issue. Let us say you are the person that wants an application determined, an appeal considered, or advice provided, and the public authority in question is being slow or refuses to visit the site. Well, what can you do? All you can do really is to try to persuade that public authority to carry out their statutory functions. And in doing so, I've suggested it may be helpful to look at the most recent planning update on the government's website, which emphasizes the expectation that the planning system will operate flexibly so as to function as near normally as possible. And note too, that although asked to do so, the government has not extended determination periods. So a degree of ingenuity is expected on the part of planning authorities. Thank you. Could we go to the third section of my presentation and the case of Dill? And I could sum up all I want to say about this case in one sentence, really. My essential message is read this case. It's a pleasure, and it's also most informative. Let's take it in a little more detail now. The legal question it grapples with head-on and decides is, who decides what is a listed building? Now, you may not have known, most of you may have done, given that this is your daily bread, this area of law, but you may not have known that 27 dinosaurs in Crystal Palace are listed grade 1, listed buildings, grade 1, and that Henry Moore's reclining figure at Dartington Park is listed grade 2. Next slide, please. But what if you receive a listed building enforcement notice and do not agree that the thing, or the item, to use the term adopted by Lord Carnwath in Dill, in question is a building at all? This is what happened to Mr. Dill. Then you certainly should read this case. Mr. Dill had removed 2 urns from the grounds of his grade 2 house and sold them at auction. Years later, a listed building enforcement notice required him to return them. He, as I've said already, did not think they were buildings at all. Sorry, stay with this slide. Thank you, Emma. I've highlighted, I've arranged section 1 and the definition of listed building in this slide in a way that's intended to draw attention to the distinct definitions. A listed building might be an item, might be a listed building because it's a building which is for the time being included in a list, or it might be curtilage listed or fixed to the building. These 3 ways of qualifying are distinct, and in Dill, the urns that were at issue in that case were listed in their own right. So the crucial question was, were they a building which is for the time being included in a list? Next slide, please. That picture is of one of the urns in Dill. I may be a Philistine, but I must admit I saw this picture and wondered what the fuss was about. But it's the urn on top of the plinth that apparently contains the interest, and I'm sorry if I've offended those who see its merit better than I. In terms of take-home points in this case, there are 2 legal and 1 policy point, and I've summarized them very briefly here. First, legal point. An appellant can question the list in a listed building enforcement notice appeal. And if they do so, it's for the inspector to decide whether or not an item, such as an urn, is or is not a building contained on the list. And second, the question whether an item is a building is a judgment, but it's a judgment for which the Skerritt's criteria are relevant. You will recall that the Skerritt's case is the Court of Appeal authority on whether a marquee was a building for the purposes of the Planning Act, and it's been adopted by the Supreme Court here for very obvious reasons, the similarity of the definitions. And the policy point is the very clear indication that the Secretary of State should clarify his guidance on the qualifications for listing. Next slide, please. Thank you. The Supreme Court notes the disturbing lack of clarity about the criteria which have been adopted by the relevant authorities. In determining whether freestanding items such as these are regarded as qualifying for listed protection under either limb of Section 1. Also, and this is particularly important, the critical distinction identified by the court between the two limbs of Section 1 is blurred in the 2018 DCMS guidance on principles of selection. Next slide, please. The Supreme Court also gave guidance on whether a curtilage structure forms part of a listed building. And summarizing paragraphs 38 to 44, we are to consider how and how permanently the item is attached to the land. There is no rule that it must be fixed to the land. It could be held in place by its own weight. But if it's neither physically attached nor directly related to the design of the listed building or its setting, it is not a curtilage structure. Very clear. Listed building, is it a building? Supreme Court guidance on the definition of building for Section 1 purposes, I've summarized here from paragraphs 45 to 56. Use the three-part test of size, permanence, and degree of physical attachment adopted by the Court of Appeal in Skerritts. There is a need for something akin to a building operation when putting the thing up, when erecting the structure. And the court would expect the historic interest to be found not merely in the object, but in its erection in a particular place. Next slide, please. So those were my thoughts on DIL, and I'm summarizing the three sections in this slide. First, the consultation on Historic England's draft advice note on major renewable energy ends today. It does not extend or alter planning policy, which remains, in my view, somewhat opaque, both in England and Wales, although for different reasons. But nor can it. It is technical advice and not policy. In the second section, I discussed the coronavirus, which makes things more difficult, but generally speaking, not impossible. And thirdly, the question, what is a listed building, has a highly readable and authoritative answer in the Supreme Court's judgment in DIL. Thank you very much. I know that Emma Dring is going to introduce the questions if you are still with us and to the extent that you're willing to continue to listen. Thank you.
Thanks very much, Harriet. Some really interesting topics. I think heritage as an area never ceases to throw up interesting topics for discussion, and I feel like we could have probably covered a second webinar easily with all this material. We have, I think, a little bit of time just for some questions. I think, Harriet, there's one that's just been asked on the question and answer. It's been very quiet throughout, but one's just been asked on DIL, so I'll leave that for you. But I'm going to answer a couple of the pre-submitted questions that we had, and we had a lot of very interesting questions. And I wanted to first answer a question submitted by Elaine Milton, who said it would be helpful to know of any rulings regarding how harm is categorised as substantial or less than substantial, so really the boundary between less than substantial and substantial harm. And essentially, there's still only really the Bedford case. It's the only court judgment in which that issue has been tackled head on, the definition of substantial harm. It was a 2013 case. It hasn't been considered in any later cases as yet. It's one that's always getting aired at inquiries. Those phrases that we will all have heard many times about significance being very much reduced or drained away, and really it's all things to all men, usually relied on by developers as setting a very high test, objectors tend to argue that actually what was actually decided by the judge was more limited and the PPG has moved on. But it doesn't really, there's not really any other court judgments. PPG's been amended a lot since then, and that makes clear that substantial harm's a high test. It can arise from setting impacts. There were initially some suggestions that wasn't the case, but there have been various appeal decisions that have found substantial harm from setting impacts. And the question is the extent of harm to significance. And if you're really interested in the arguments on this point, on Bedford and substantial harm and what it means, I would recommend looking at the inspector's report in the Chiswick Curve case, because it obviously sets out both parties' cases. You can see a recent and very detailed discussion of the arguments either way in that case. So I don't think, unfortunately, we can give much more guidance than is already out there, and that in itself is limited. And I'll just answer one more topic of questions before I pass over to Harriet, which is questions asked by Susan Leeson and Gavin Cooper, essentially about no harm. Should there be a no harm classification rather than less than substantial harm? And why is no harm considered to be less than substantial harm? Well, in effect, there is such a classification of no harm. This point was covered in a case called James Hall and Company and Bradford Metropolitan District Council, where the judge said the MPPF recognises 3 categories of harm: substantial, less than substantial, and no harm. Basically said even if harm is minimal or even negligible, that's still less than substantial harm, although if it's limited or negligible, that obviously goes to the weight to be given to it. So I think the short answer is if there's absolutely no harm at all, then the policy tests in paragraph 195 and 196 just aren't engaged. There's no heritage impact. If there's just a very small amount of harm, even if it's negligible, you do have to go into that exercise and strike the balance. But of course, if it's very minor, it may not take much by way of benefit to outweigh that harm. Harriet, I'll pass over to you to answer 1 or 2 questions now.
Thank you, Emma, very much. I was just typing an answer to a question about DIL, so I will address that very briefly first and stop my typing. This was a question based on the premise that the urn was a curtilage listed structure. I tried to be as clear as I could be. It may be I've muddled some. The whole point in DIL was that the urns were listed in their own right. They were not listed by virtue of being within the curtilage or related to another building. They were said to be buildings. And they were said to be buildings simply and solely because they were included in the list. And what the change that the Supreme Court has made is to say an item may be included in the list of buildings, but you can still argue that it is not a building and therefore does not belong there in your appeal. I hope that's clear. Yes, the other area on which a number of people asked questions was on non-designated heritage assets. And really, the picture is very similar to that relating to designated heritage assets. The MPPF has a paragraph on them, 195, and we can see the balance there to be struck depends upon the scale of harm and the significance of the asset. These are value judgments which will depend on a case from case to case. And it's very, very difficult to say how they might be struck without the details of an individual case in front of you. Is there help within the PPG? Well, there's actually quite a lot in the NPPG on non-designated assets, but in the end, it simply states the obvious, namely that identification of a non-designated heritage asset must be based on sound evidence, and that the balance that must be struck must be carried out carefully. that therefore is really all that can be said on the subject. Not sure if we're going to pick up any more questions, but that's all I've got for the moment. Thank you.
I think given that we've got a couple of minutes, I will just touch on one final point. And in fact, I'll go back to one of the slides which I skipped over earlier, only because I just think it was a really interesting issue. Now you have to bear with me while I skip all the way back, because I can't think of a quicker way of getting back to where I wanted to go. It's this point because there were, I think, 3 people that asked this question about scales of less than substantial harm. Samantha Allen, Susan Leeson and Caitlin Boddy all asked questions on this theme. Essentially, is there a scale? Because they're often getting suggestions that is the case. And certainly back in 2018 in Shimbles, the High Court looked at this argument and basically said the NPPF only has those 2 categories of harm. That's enough to enable the balancing exercise, and they didn't want to impose any further subdivisions because it would overcomplicate matters. Essentially, what that case decided is that it's not an error for a decision maker to fail to place harm on a scale. There wasn't a legal duty to do so. And I should say I was actually instructed to seek permission to appeal to the Court of Appeal on that point and other points, but that was refused by the Court of Appeal. And clearly it is something that you see a lot in practice, both by consultants, decision makers, inspectors do actually in practice place less than substantial harm on a scale. And interestingly, and this had passed me by, but I noted that the amendments to the PPG that were made in July 2019 do actually now give some guidance on this, and it says now in terms that within each category of harm, the extent of the harm may vary and should be clearly articulated. So I think, although there may not be a legal duty as such in the NPPF to do that, clearly that's a recognition that it's best practice to be specific about exactly what the harm is, how serious it's thought to be, and obviously that will go to weight. And there was a further question on the topic from Samantha Allen about how involved heritage specialists should be in informing that judgment on scale. And it's obviously something that is within the remit of heritage specialists. They can suggest if the harm is, for example, towards the bottom end of the spectrum or the top end, and that will help to inform the decision maker in terms of how they strike that balance. But of course, ultimately, that balance is for the decision maker themselves to strike. And I think that does now take us to the end of our hour. So thank you so much. I've just seen a few more questions popping up. We'll try and follow up with those people that we weren't able to cover their questions during the presentation. We'll try and follow up where we can afterwards. But otherwise, thank you very much for listening. And I hope you all have an enjoyable afternoon. Thank you very much.